Hello, good morning. Thanks for joining me. My name's Ian.Machray, and I head up the employment law team here at Field Seymour Parks. And obviously today we've got our webinar on the IR35 changes that are coming in for the private sector. Very much fast approaching in April. Yeah, thanks for joining me today. So before we sort of get started, I'll give you a little bit of a run through as to how the process will work today. So let me get that up. So yeah, unfortunately, as you will all have noticed, you are all on mute. Unfortunately, it's the only way really to sort of run a session sensibly with the numbers we've got today. But please do type your questions in. So there's a question box that should be on sort of the sidebar of your screen. Please do type them in as you go along, and then what I'll do is I'll leave some time at the end and I'll open that up and I will try and answer as many of your questions if you popped in there as possible. So please do stick them in there. You also have the opportunity to engage in some polls as we go along. So I've got a few sort of questions I'll ask you as we sort of get into the session, and you can just sort of click and vote on those. And yeah, so if you can engage in those, they were great. It will remind me that I'm not just speaking to a camera and there is somebody out there on the other end of it. So yeah, please get engaged in those. If you want the slides, you will see again in the sidebar, there should be a little handout section. You should be able to download them from there. But any issues, let us know and we can get them out to you. And then final thing I'll flag up before we sort of get into the session is once we've sort of done questions and I've shut the session down, you'll have a opportunity to just leave some feedback. And if you can do that, that would be great. It should only take a minute. And it's really helpful to us in trying to make sure these sessions are as useful as they can be. The other reason for doing it is one person will be drawn at random to get £50 of John Lewis vouchers as well. So two good reasons to fill in the feedback form at the end. So thanks for that. Oh, and I guess the third reason is if you want to get details of some of the other resources and things that we do, you can tick a box on there and we'll make sure you get notice of any further webinars, our podcasts, and maybe one day this year we might do an event in person. You never know. As you can probably guess from the backdrop, this is coming live from my spare room, my delightfully decorated spare room. Hopefully we won't have any technical issues, but if we do, please bear with me and I will do the best I can. Right, let's crack on and look at what we're going to be talking about today. So the plan for the session today is broadly sort of splitting it into three parts. Going to give you sort of an outline as to how things currently stand in the private sector, partly on the basis that some people may not be fully aware of how the law operates now, but also it gives a good grounding for explaining what the changes are that will come in April. We'll then look at what those changes are and what the impact of those will be coming in on the 6th of April of this year. And then we'll sort of finish off with sort of next steps, actions, practical advice, things to consider, that side of it. There are some bits of this. It's obviously a huge topic, and I've tried to sort of focus it today on the sort of the preliminary steps, the stuff that you really need to sort of know now with a view to the 6th of April date. So I won't get into some of the more technical aspects of how you would account for tax if you have someone in deemed employment and within these sort of these changes from the 6th of April. So some of the stuff around technically how you make those deductions, some of the rules around double taxation, statutory payments, won't have time to get into those today, unfortunately. But obviously if you've got questions on those areas, you can let me know. Equally, won't be talking about the public sector because the changes are for the private sector. As you'll see and as I'll explain, the changes roughly mirror what has already happened in the public sector, but the focus of today's session is on the private sector. So just to make sure there is somebody out there, I will ask you a question to get us started. So what I'm interested to know is how far along you are with your preparations for the April changes. I should add this is entirely anonymous, so you can answer very honestly, and you should be able to click through as and when you're ready. And essentially, I've given you 4 options. So 1, you don't fully understand the current position or indeed the changes. 2 is that you understand the current position but not aware of what the changes mean. 3 is the third one is you broadly understand it all, but you might have some specific questions or issues. And then the 4th one is that basically you know all about it and you're volunteering to take over this session, which I don't think I can do, unfortunately, but yes. So please vote away, and I will then get up the results to see how people are doing. Obviously, there's a lot of speculation in the press recently in terms of how prepared people are. Right, I'm giving you long enough. Let's have a look at how you're getting on. Let's close that off and share my results. So we've got a broad mix. So we've got about just over a third of you, I guess, who really need to understand the current basis as well as the changes. And then we've got a similar amount, I guess, who got a good understanding of both, but got specific questions or issues. And then a few who need to know about the changes but have a good understanding of the current position. Well, hopefully after today you'll all maybe not be in category 4, but at least a bit further along in terms of your knowledge of what you've got to do and what's happening. So without further ado, let's move on, and we will start as I flagged up with a little bit of an explanation of the sort of the current position. So IR35 introduced on the 6th of April 2000, and the idea behind it, which is useful to bear in mind when we're talking about this whole area, is that its aim was to crack down on a form of perceived tax avoidance. And what the government or the revenue thought was happening was that individuals were avoiding paying income tax and national insurance contributions by supplying their services through an intermediary, which is a term we will use a lot in this session, and indeed we will we'll explore a little bit more exactly what that is. But typically a personal service company, so a company that is owned and controlled by an individual. So they might be 100% shareholder, sole director of a company. And the way it would work or potentially worked would be that the company would contract with an end client. The end client would pay the company on production of its invoices. And then the individual would draw money out of the company through dividends. So instead of paying themselves a wage, they'd take the money out through dividends, and the revenue and the government was concerned that actually what was happening is this was a way of avoiding PAYE, income tax, national insurance contributions by drawing the money out through dividends rather than it being through payroll. So that was the concern. That's why it was introduced. Let's have a look at how the situation currently sits in the private sector. So in very simple terms, you need 3 things for IR35 rules to apply. First one is where you've got an individual performing services for a client personally. That's relatively straightforward. Second one is there needs to be this idea of an intermediary. So the services are provided via an intermediary. And don't worry, for those who aren't clear on that concept, we'll explain that. And then the third one is that the worker would be deemed an employee for tax purposes if it were not for the intermediary. So if you stripped away the contractual arrangement, you took the intermediary out of the picture, would the individual be an employee? Do they look and smell like an employee, basically? And we are going to focus on 2 and 3 of those 3 stages tests, because the first one is reasonably self-explanatory. So we're going to look firstly at the idea of what is an intermediary, because you need one of those, and then we'll look at this idea of deemed employment. Okay. So intermediaries. So it can be a company, a partnership, or much more rarely an individual, where it might be something like a sort of a gang master or something like that if it's an individual. But the individual, the worker, has to receive income from that intermediary that is not taxed as employment income. So in my earlier example, we were talking about them drawing out dividends, which obviously isn't taxed in the same way as employment income. It can't be an associated company of the end client. So if it's another company within the corporate group, it will not qualify as an intermediary. And then you have this question of the interest that the individual has in that company. So there are three sort of scenarios. And I'm going to look at companies because it's the most common. There are similar but slightly different rules for partnerships. But companies is the most common one. And if the individual has a material interest in the intermediary company, which is normally 5% plus shareholding, or it can be, again, the same percentage right to sort of distributions, so dividends, or indeed assets on winding up. And if they have that material interest, that 5% plus interest, directly or indirectly, then they'll be deemed to have a material interest in that intermediary, and that will qualify then as an intermediary for the purposes of IR35 regulation. Now, there's a slightly different scenario, which is where there is a non-material interest. So say your worker has a very small, under 5% shareholding in the intermediary company. That does not automatically mean that IR35 doesn't apply. But there are some, it can do, but it has to meet additional requirements. So if it's a material interest, then it will qualify as an intermediary. If it's a non-material interest, so a much smaller interest, then there are additional requirements to be met for it to fall within the IR35 scope. And those requirements are that in addition to that, the worker has to receive what's called a chain payment, and that chain payment cannot constitute employment income. So again, we've got this point, which you'll see throughout this, that if the individual is already paying tax as an employee somewhere along the chain, then the IR35 regulations don't apply because they're already paying the tax they should be. But if, for example, there is a payment being drawn out by, say, way of dividends, and that can be constituted as a chain payment, so a payment that can reasonably be taken as being a payment for the worker's services, then it falls within IR35. So to give you an example, if, for example, you have your sort of personal service company, or let's not say it's let's just say you've got a company intermediary, we've got a non-material interest, so maybe it's not a personal service company, we've got under 5% interest, but the worker draws out money from that company that is not taxed as employment income and is linked to the services they've provided, then it's probably going to be a chain payment and within IR35. An alternative might be where you've got a company, again, a small under 5% shareholding the individual has, and they are also, let's say, they have some shares in the company which they've secured through some sort of option scheme over the years, and they get paid some dividends as a result. That will not be a chain payment, assuming those dividends are not linked to the services they've provided. So they're not linked to the value or the type or extent of the work that the individual has done, but are linked to a different commercial arrangement. Then it wouldn't be a chain payment. But so you need to establish if there's a material or non-material interest, because you've got this additional requirement if it's a much smaller shareholding. If there's no interest at all, so there's no sort of shareholding, there's no sort of material or non-material interest, then IR35 won't bite. You won't have an intermediary for the purposes of the legislation. Okay. So what might help, for those of you who are unfamiliar with these sort of concepts, is just to look at a very basic diagram. Unfortunately, my graphic design skills aren't up to much. But what you've got here is at one end of the chain, sort of the contractual chain, you have the individual worker who's providing the services. They then have an intermediary, and let's assume, for keep it simple, that that is a personal service company. So it is a company that is wholly owned and controlled by the individual. That company then has a contract with the end client to provide services. Client would then pay the intermediary on production of its invoices in accordance with its contract, and then the worker would draw funds out from the intermediary, classically by way of dividends. Okay, and that is the classic situation you'd have where IR35 may well apply, because there's no sort of employment taxes being charged. Certain types of relationships are not covered by IR35. So if that worker was directly engaged by the end client, so look at that diagram and take out the intermediary in the middle, you've just got a direct contract between the individual and the client, that is not covered by IR35 because there is no intermediary, there's no one in the middle. You may still have issues if they look like an employee, because they might have statutory rights and things of that nature, but it's outside the scope of IR35. If you've got agency workers who are employed by the agency, again, that's outside of scope. So if we replace our intermediary in this diagram with a recruitment agency, and that recruitment agency has an employment relationship with the worker, that's outside of scope. Again, for the same reason that the worker will be paying tax on its earnings. So as long as employment taxes are being deducted, then the revenue is not concerned about it. Similar thing with umbrella companies, although be a bit careful with those because that does change. That term is used quite loosely. But if you've got an umbrella company where they employ the workers and they're taxed, then again, it's outside of scope. And obviously, if you've got someone who is an employee, then they are outside of scope as well, because again, you're taxing them in the normal employed way. So that's the idea of an intermediary. We will come back to these sort of contractual changes in a little bit more detail because they link in with some of the concepts around the changes in April. But that you do have to have an intermediary somewhere in the chain for the IR35 regs to bite. So what I'm going to move on to next is the idea of deemed employment. And to get us started on that, I'm going to ask you another question. So let me get it up on the screen for you. So will the right to provide a substitute in a contract mean that the individual is not in deemed employment? And you've got three options: yes, no, or maybe. Please vote when you're ready. So by providing a substitute, essentially what I'm for those not familiar with that sort of terminology, is the idea that there is someone who principally provides the services, but they have a right to send somebody else to do those services instead of them. If they have that right under the contract, will that sort of kill off any chance that they could be deemed an employee for the purposes of IR35 regulations? So I'll give you a couple more moments. This is ultimately getting into that third stage of the test I was talking about, which is this idea of whether there's deemed employment. So if you strip away the contractual relationship, would the individual be an employee? So let's close that down and have a look at the results. Yeah, so a mixed, and I have sympathy for all of you with this question. Well, not so much a trick question, but certainly not an easy one to answer. So 38% think yes, the right to provide a substitute will mean there's not deemed employment. Got 15% saying no, it won't, and the 46% sitting on the fence there saying maybe. And we'll look at this, but the answer in short is it depends. If you have an absolute right to provide a substitute, and that is unfettered, so there's no restrictions on it, and that right to provide a substitute is likely to be used or will be used in practice, that probably does mean that there's not deemed employment. So those people who said yes are right in those circumstances. But if, however, you have a sort of a fettered right to provide a substitute, i.e. there are a lot of restrictions on what that substitute can be, maybe a right of refusal, and or that that's very unlikely to be used in practice, never been used in practice, then there's a good chance it won't have any real impact. And those people who said no, it won't have an impact and they could still be in deemed employment may well be right there as well. But ultimately, it is one of many factors. And let's get those up. So before we get, this is sort of a brief summary of sort of some of the different factors that need to be taken into account when assessing whether or not there's this idea of deemed employment. First thing I should flag is that the tests for whether someone is in employment for tax purposes and whether they're in employment for employment law protection purposes are slightly different. There's different sort of classes of sort of employee under employment law, and also you could potentially have someone who is taxed as an employee but actually doesn't tick the boxes for employment law purposes, and vice versa. So they are similar tests, but they are not identical. And what we're looking for with IR35 is whether or not they would be an employee if you stripped away the sort of the contractual arrangement, the intermediary and everything else. It doesn't follow from that necessarily. Indeed, it's probably relatively unlikely that they would be an employee of the end client for sort of statutory protection purposes. This is a tax test, okay? But the first thing on our list here is this idea of personal service. So this goes to our substitution. And obviously with an employee, there is an expectation that if you have an employment contract with Joe Bloggs, it is Joe Bloggs who turns up and does his job, and he doesn't send his neighbor in one day because he doesn't feel like getting out of bed. And therefore, the more you are in a situation where it is an individual personally providing service, the greater the risk is that someone will be in deemed employment. If you're at the other end of the scale, or closer to the other end of the scale, whereby actually there is no real requirement for personal service, people can provide a substitute, there's very limited restrictions on that, and it is done in practice, or likely to be done in practice, then again, that would be a pointer towards self-employment and not a deemed employment relationship. The key with all these factors is to not just look at the contract, but to look at the reality of the relationship. So even if you have your clause in the employment contract, if that does not match up with the reality of the relationship, then that won't be conclusive. It's the whole thing that gets taken into account. Mutuality of obligation is one of the other key factors when trying to determine if there is deemed employment. What that means in a classic employment relationship is that there is an obligation to give work and there is an obligation to do it. So Joe Bloggs has to work from 9 to 5. That work is guaranteed to him, but he is also guaranteeing he's going to turn up and do it. In some self-employed relationships, you don't have that. You may have no obligation to give work at all, and indeed when offers of work are made, the self-employed individual may have no obligation to do it until such time as they accept the offer. So that's something to have a look at. We will a little bit later on look at the online CEST tool, which is available to help determine whether or not there's deemed employment, but it doesn't correctly reflect, or at least I would say it doesn't correctly reflect the impact of mutuality of obligation on that test, but we'll come on to that in due course. Right of control is another factor, and you'll have seen the headlines recently on the Uber case. Now that wasn't an IR35 case, it wasn't a tax case, that was about employment status for the purposes of holiday pay and employment law protections. But where they came a cropper in that case is about the control they operated over their drivers. And it is a point that is relevant also to these tax decisions, because the more control you exercise over an individual, whether during or after the engagement, the more likelihood they will be in deemed employment. And that's on the basis that your employee is obviously giving personal service, you're normally tying them in, you may be giving them directions on how, where, and when to do their work, whereas a self-employed relationship, is more classically to do with service deliverables. So there may be something that is required to be delivered or required to be done, but there is much more flexibility about how, when it is completed. So that's something to keep an eye on. The other thing to think about is not just during the relationship, but it was also at the end of it. So employment contracts, particularly for senior employees, will commonly include restrictions that extend beyond the employment relationship. So sort of post-termination restrictions: you shall not work for a competitor, you shall not steal our clients, etc. If you have those in a self-employed contract or in a contract with an intermediary, again, you're not only exercising control during the term of the engagement, but afterwards. And again, it's another factor that points towards deemed employment. Again, all of these things on their own are not necessarily determinative. It is looking at the whole picture. Provision of equipment, one of sort of the age-old sort of tests for this thing, on the basis that the self-employed person turns up with their own tools, and your employee gets provided with them. Less of a factor in some sectors, but you might still be thinking about, even in service sectors, you might still be thinking about provision of IT equipment, provision of mobile phone, access to computer systems. Is that something that the end client provides, or is it something that the individual or the service provider has to put up? And again, the more that the individual is having to provide that equipment, again, the greater likelihood that they're self-employed. Financial risk kind of overlaps with that a little bit. Are there costs that need to be met before the contract can be performed, which could be going out and purchasing some equipment so you can do the job, or it could be the fact that the sort of self-employed will normally bear greater financial risk. So, for example, if you do a bad job, that you may have to put it right at your own expense. Whereas if an employee does a bad job, then normally they just they can spend an extra day or whatever putting it right, but you're going to be paying them for their time. So think about the financial risk that is there. Again, those who are self-employed will normally have greater financial risk. Length of engagement. Classically, self-employed individuals would be on a project basis, against sort of measured against sort of deliverables, whereas employees normally much more long-standing arrangements, much more flexible in terms of the duties that might be required to be performed. Integration is one that people often sort of look like. Again, not determinative on its own, but you might want to look at the extent that people are integrated into the client organization. So do they have an email address of the end client? Are they on the phone list? Are they on the website as being a member of staff? Are they on internal contact lists? Uniform, all those sorts of things. Would an external party be able to easily identify them as self-employed? Or would, if they walked in and saw them working away, would they think actually this is an employee of the end client? Okay. And that is one of the areas that is sometimes easier to do something about. Some of the other aspects are slightly more difficult sometimes. Benefits is similar again. Again, you want there to be a distinction between your employed and your sort of self-employed staff. Obviously, self-employed people don't get the same statutory benefits as employees, statutory holiday, statutory sick pay, etc. You might also just want to have a think about incentive bonuses, things of that nature. If you are making similar payments to the self-employed that you do to your employees, again, that's a risk factor that they may be in deemed employment. And then the intention of the parties. Well, this gets back a little bit to the point I was sort of making at the outset, in that you have to look at the entirety of the relationship. The contract will not necessarily be determinative, but that said, if you and the intermediary or the individual believe and wish that it will be a self-employed relationship, it would make sense for that to be expressed in the contract, but don't rely upon it by itself. And then a few other factors which can cover anything really. But you might explore to the extent that the individual is in business on their own account. So do they have to do their own marketing? Do they have to secure their own work? Do they work for other people? Or is it actually the case that they are sort of recruited into your organization in a similar way to an employee? Or, you know, did they come knocking on your door offering their services? Again, if they're sort of been recruited in, it looks a lot more like an employee. If they've been out touting for business, or they have to go out touting for business, it looks much more like a business to business type relationship. Okay. So a whole lot to consider there. The idea of sort of deemed employment is a whole topic in itself. We will come on later, sort of the online CEST tool and how that may be able to help you with that process. One other little angle that I wanted to talk about is the issues that can arise with office holders. So most often sort of directors, and they have also been potentially caught by IR35 since 2013. And there's two ways it can potentially be caught. The first one is where you almost have sort of a corporate sort of office holder. And again, if the individual would have been an office holder were it not for the intermediary, so was it not for the contractual arrangement that's in place, then again they can get caught by IR35. And if second one is if there's a provision of services by a director via a personal service company that is linked to their role as a director, again that can be caught as well. And the reason this is relevant is that if you hold office as a director or as an office holder and charge fees as a result, normally they're taxed as sort of in a similar way to employment income. And therefore, if you are trying to provide those services by a personal service company, you just need to be careful that you don't get caught with the IR35 legislation there as well. So if you have a director who is also charging services through a personal service company, that is something to look at and just investigate. It might be okay because the services might not be linked to their role as a director, but certainly one to check out in the same way as you'll have to do with some of your classic IR35 issues around employees. So what does it mean? So I've been talking quite a lot about whether stuff's inside or outside the scope of IR35. Well, what does it mean if it is inside scope? Well, essentially under the current position, the personal service company or the intermediary has an obligation to assess whether or not there is deemed employment. So those tests and factors we were running through, currently they have that obligation to look at all those things. And if they conclude that there is deemed employment, they have to account for the tax and national insurance contributions that are due. Now, the issue the government has had with that is they don't believe that personal service companies, the intermediaries, have been doing that properly. They don't believe they've been properly assessing whether or not there's deemed employment, and therefore they want to move the responsibility for those tests and applying tax. And that's one of the key changes. So let's move on to those changes now. So that was a whistle-stop summary of the current position. What we now have on the 6th of April is some changes to how that operates in the private sector. And these roughly mirror the changes that were brought in for the public sector in 2017. Now, the key thing to note is in terms of whether or not these will impact on an end client, so the beneficiary of the services that are being provided, there is a size threshold. So if you are a small company within the definition we'll look at, then these changes will not impact upon you. And basically that existing position that we've just looked at will still be the case, namely responsibility for tax, and these issues will sit with the personal service company or the intermediary. However, If you are a medium or large company, which basically means if you exceed any two of these three thresholds, then you will be caught by these changes and you will have additional responsibilities. And those are 10.2 million revenue, 5.1 million assets, and 50 employees. It's two of the three, and you are then caught by these changes. Now, it is key to note that this size requirement focuses on the end client. It doesn't focus on the size of the intermediary or any agencies in between. It's the end client. Okay. The other thing I would add is that if a company is saying that it is small and outside of scope, you do need to look at its wider corporate structure. Based in very simple terms, the parent company, if there is one, would also have to qualify as a small company as well. So setting up a tiny subsidiary doesn't get you outside the scope of the regulations. One little point to note there in terms of timing of it is in assessing the size, that is done on the last set of accounts before the tax year in question. Okay, and if you shrink in size, so eventually you become a small, so you're in scope to begin with, but at some point you become a small company, you only get outside of scope if you've met those conditions for 2 consecutive financial years. So once you're inside of scope, even if you shrink down, it takes a little bit of time before you can drop down. One final point I would note here, which some of you may have seen already, but if you do have workers providing services, they can formally request confirmation from you as to whether you are a small company and therefore outside scope of this, or whether you are a medium or large company. And you have 45 days in which to respond to that. So that's something to keep an eye out for. And the reason that's there is ultimately, if you are a small company and these changes don't impact, then the tax responsibility still sits with the personal service company or with the intermediary, and therefore they need to know that, because they need to know who's got responsibility. So what changes? In very simple terms, there's no fundamental change to the underlying IR35 rules. So this idea of deemed employment and whatever is still the same. That's still the same, but it's about who has responsibility for assessing this and making sure the tax is paid. And ultimately, the end clients of a contractor who's using an intermediary become responsible for determining the tax status of the contractor. So again, this, I'm now assuming going forward, I should say that we've got a medium or large end client, because if we don't, then you're not impacted in any event. So responsibility shifts up to the end client. They have to produce what is called a status determination statement, which is all about whether or not there is deemed employment. And if the end client decides that the contractor does have deemed employment, then tax basically needs to be accounted for by what's called the fee payer. The fee payer could be the end client, or it may be possible to pass down liability for that tax down the contractual chain. Okay, but don't worry, we're going to explore that in a little bit more detail. But essentially, it's shifting responsibility for determining tax status, and shifting responsibility for accounting that tax up the contractual chain towards the end client. So it follows from that, maybe somewhat obviously in terms of those people who are affected, that if you are an individual supplying your services through an intermediary to a client and they are medium or large, then you're obviously going to be impacted, because there's going to be a shift in terms of how your tax is calculated and worked through. Medium or large clients in the private sector that engage with intermediaries for the provision of services, again, will be impacted, because you'll have responsibility for things you didn't have before. And if you've got a middleman type operation where you are supplying workers who operate for an intermediary and are not subject to employment taxes currently, again, there's an impact there. But go back to that point I made at the start, that if employment taxes are being accounted for somewhere in that chain and tax is already being paid, then it shouldn't impact on that individual. So if you've got an employment agency where they are employing their workers, that's going to be outside of scope, which is the same as it currently is. So if we look at the end client then, so you are a medium and large organization, what do you need to do? Well, you have to determine your workers' deemed employment status. So all those factors we looked at before, you have to look at those and you issue what's called a status determination statement. And what that basically is saying, is there or is there not deemed employment, and the reasons for that. So reasons why yes, you think there is, or reasons why there isn't. And you have an obligation to take reasonable care when determining the status of your workers. Okay, and if you don't do that, then there may be tax consequences for you. So it is important to get it right. You then have to send that status determination to the individual, and if there's a middleman, an agency of some sort involved in that chain, you'd have to send that to them as well. Now, the question I have for you is on what are the implications if someone disagrees with the assessment. So under the new rules, we've got a medium or large end client. They've done their assessment of the individual as to whether or not there's deemed employment. They've said they think this individual is and it would be an employee. Can that individual says, well, this is nonsense, you've got this completely wrong. Can they bring a claim against the end client to say, you've got this status determination wrong, you're now making deductions that shouldn't be made, and I'm going to bring a claim against you as a result. So I'll give you a minute just to vote. It's a trickier question, probably, this one. All right, let's close it down, have a look at what you think. So 71% of you think yes, and 29% of you think no. Well, the short answer is that there is no provision under the regulations for a claim to be brought against the end client. Okay, there is always the possibility of some form of contractual claim if deductions are being made and there's an argument to say they're not permitted under the contract, but broadly speaking, there is no claim under the regulations against the end client directly. Okay, which some may disagree with. What there is so just before we move on slightly, I'll just bring you back to this CEST tool piece, which I talked about earlier on. So as I say, you've got this responsibility for doing your status determinations as an end client, if you're medium or large. And responsibility sits with that the end client. Now, there is an online tool provided by HMRC called the CEST tool. You can find it online. You can sort of fill it in without sort of providing details. And there's no obligation to use it, but the idea behind it is it helps you work out whether or not your individual is in deemed employment. As I say, you don't have to use it, but if you do use it and you enter the information correctly, taking into account not only the contract, but the actual realities of the relationship, then HMRC has said it will be bound by the output. So if you fill it all in correctly and not fraudulently, and it's accurate, and it spits out a determination that there is no deemed employment, then HMRC will not go behind that, which sounds great. The issues with it are, firstly, they doesn't properly take into account this idea of mutuality of obligation, mainly because HMRC says that there is mutuality of obligation in every contract, which is slightly at odds with a lot of the case law. Sometimes the outcomes are incorrect, as has been demonstrated by the fact that HMRC has brought a number of cases around the operation of this legislation over the years, and has a pretty poor success rate actually in terms of challenging it. But the biggest issue you have is in around about 19% of cases, you'll get an indeterminate outcome. So it won't tell you whether or not there is deemed employment or not. In which case, obviously, you would need to do further investigation and record your decision. Now, linking back with the point earlier on I said about inability to sort of bring a claim under the regulations, what you do have is an internal process. So whilst you can't necessarily go running off to a court or tribunal unless you can establish there's a contractual breach, there is a dispute process. And so when the end client issues their status determination statement, they have the ability to appeal or dispute that decision. Now they can do that orally or in writing, but if they do that, the end client has to respond within 45 days, doing somewhat obviously one of two things, either confirming the decision and giving reasons, or reversing the decision and issuing a new status determination statement. Now, one thing I would say to just be very careful of here is that there is no format for that dispute or appeal to be raised. It doesn't have to be in writing. It doesn't have to be to a particular person. And therefore, if you're an end client, you just need to make sure that your managers or whoever might be dealing with these contractors, if someone says, I don't agree with the status determination, I don't agree that I'm in deemed employment, that they then report that, because you've got 45 days to respond to that, and it could be raised orally. So it's just something to make sure you've got some processes and training in place to make sure you're picking those up early so that you can run your process. There's no set process that has to be followed, but again, you should be taking reasonable care. So it's not like a disciplinary process where it's sort of a lot more sort of, there's a formula to follow in respect of it. You've got flexibility, but you need to show you've sort of considered it and you've, as I say, exercised reasonable care on your decision. There's no cap on the number of disputes that can be raised. But as an end client, you're only obliged to consider a sort of a dispute or an appeal if it's raised before the final chain payment, which basically means but before the final payments are made under the contract in question. If it's after that, then it would be too late to raise it. I should also say that the HMRC guidance on this has said that if repeated disputes are raised without any new evidence or information, the end client is entitled to just rely upon their previous determination. So if there is something there that helps in the event of nuisance factor. Again, if there's any failure in the dispute process, then you end up with the end client being sort of the deemed employer or fee payer. So basically having liability for the tax, and that's the stick really. That is there for the end clients. If you don't get it right, it can lead, you don't take reasonable care, you don't do the dispute process, it can lead to tax liabilities as a result. So, as I hinted at earlier on, the question as to who pays when there is deemed employment can sometimes be a little bit complicated. So if we take my classic scenario at the start, where you have the end client, you have the intermediary in the middle, and then you have the worker at the end. If you have a short contractual chain like that, then it will be the client, the end client, who has to make the deductions. Okay. Now, if you have a longer contractual chain, so for example, there is another agency involved, then it is possible to pass the liability for tax down the chain. So by making a status determination statement, by complying with what you've got to do, you can then pass the liability for that tax down to the agency. And if there was an even longer chain, you could keep passing it down as long as everyone passes on the status determination. But the intermediary the personal service company can never be responsible for the tax deductions. So you can't pass it down the chain to them. It has to stop at the party before you hit the intermediary. Okay, and that person is then the fee payer, which is a term I talked about earlier on. And in short, they're the one responsible for making the required deductions. Let me give you again another one of my not particularly impressive graphics to try and explain this. So you'll see this is similar to the chain we had earlier on, but we now have another company that is in the middle of this chain. So instead of it being worker, intermediary, client, we have worker, intermediary, agency, client. Okay, now the reason that's important when you have these longer chains is there's an impact potentially on who has responsibility for making deductions. So assuming here we've got deemed employment, we've got tax that needs deducting. If there was no agency here, as I say, the client has to make those deductions because you can't pass it down to the intermediary. That is not permitted if you are a medium or large organization. However, when you've got a situation like we've got on the screen here, where you have an agency in between, what the client can do is they do their status determination. They've decided there's deemed employment. They issue that to the agency. The agency obviously passes on the status determination, but the advantage the client has by doing their status determination in this circumstance is the liability for that tax moves down the contractual chain to the agency. And it's the agency that is required to make the deductions and make payments to the intermediary net of tax. Okay, but the key thing to note is you can pass it down the chain by doing a status determination, but you can't pass it to the intermediary. That's kind of the golden rule. So even if you had 4 agencies in here, you could keep passing it down in theory, but eventually it would stop at the party that is that contracts with the intermediary. Can't go down that far. So hopefully that makes sense. Obviously, a lot of the time you won't have an agency involved and it will be a lot more straightforward. Now, you will have seen throughout this piece where I've been talking about the changes in from April, there is one key thing that keeps coming up, I guess, really, which is who is this end client? So obviously, correctly identifying the end client is crucial because they're the ones that determine whether or not they are a medium and large organization and whether or not these changes bite on them. So it's crucial to properly determine it because they are, obviously you have to assess their size, but also they're the ones that then have the responsibility for the status determination and to kick this whole process off. Now, often it will be very clear who the client is. 9 times out of 10, it will be clear there is a company that is the recipient, the beneficiary of the services the worker performs. It's quite clear who they are. Where it gets more complicated and where you have a sort of a get out, I guess, of IR35 is where you have fully contracted out services. So this is really where you are outsourcing services wholesale as opposed to getting an individual come in and perform services for you. Okay. And in those circumstances where you have sort of fully contracted it out, the end client may be that service provider rather than the ultimate beneficiary of the work that's being done. And what you have to do when you have these sort of scenarios where you're trying to work out, do we have fully contracted out services? Are we sort of outside of scope? Is in effect, you're looking at which party is most akin to an employer. Okay, and again, it's a question of fact. You can't just sort of label your contract as fully contract out service contract. That won't do it in itself. You have to look at the contract itself. There's various different factors. First one is look at the nature of the business. So if, for example, you are contracting for the supply of a cook and you run a catering firm, that is highly unlikely to be a fully contracted out service because it's an intrinsic part of the business that you do. To give you an alternative example, if you had a contract for the upkeep of your website and some IT support, and you are a catering firm, that is much more likely to be a fully contracted out service, because it's ancillary to your main business. It's something that you can see on the face of it as to why you'd be passing on responsibility to another party for that. But it is only one factor. Other things to look at is it's normally a package that's being supplied. So sometimes that might mean that there's goods as well as labor being supplied. But what you're really looking at is that it's a contract for sort of a packaged service. So not for just the provision of an individual, but actually for a particular service. And that could include goods, it could include other things beyond the mere supply of just an individual labor. Normally, you would expect that service provider, so the company you're outsourcing to, you would normally expect them to have an opportunity for profit beyond just making a percentage on the fee that's being charged. So, so that it is an opportunity for genuine sort of profit there, rather than just a sort of a middleman type agency type fee being charged. And then your final factor to look at is, as I hinted at earlier on, who most looks like an employer. Is it the end beneficiary, so our catering firm in this scenario, or is it the service provider underneath? So who has the most control over the individual? Who is bearing the risk of that individual? Where are they most integrated? Are they most integrated into the catering firm, or are they most integrated into the tech firm that's supplying these web and IT support services? And if you conclude that actually you've got fully contracted out services, then what that means is that the responsibility for IR35 does not rest with sort of the end client, the end beneficiary, our catering firm. Doesn't mean it's gone away entirely, because it might mean that the service provider, our IT company in my somewhat dubious example, they may still have responsibilities under IR35 if they are a medium or larger organization, but it doesn't, the chain doesn't extend up to our catering firm. It stops there. They're the end client for the purposes of IR35. Okay, as I say, that's a concept that is sometimes very simple and it's obvious. Other times it can be quite complicated. So that's an area I'd say take advice on if you're in doubt. Few things then, and I'll run through these reasonably quickly because I want to leave some time for questions. What is the impact of this? Well, if we've got deemed employment and you're within scope of these changes, there's costs to the fee payer. So it could be the end client, they could have passed it down the chain, but you've got NICs that need to be paid, you've got apprenticeship levy, and ultimately there's an impact on the individual at the end of the chain, because if they've taxed themselves as self-employed before, they may now be receiving much less money than they have been previously. 6th of April is obviously when this all comes in, and that's when you're meant to be beginning making deductions if they're due. So if you weren't already aware, time is short. What I would say is what we are seeing to date is when people have got issues with people being in deemed employment, it is rare for them to continue with that relationship. And just say, okay, fine, well, we're going to just make the deductions that are going to due, we're going to make the contributions that are due. Reason being is it's a cost that hasn't been anticipated by the parties. And what many will then do is look to terminate that contract, and then, if necessary, re-engage on a different basis. So sometimes they're coming in as employees, sometimes there's an umbrella company being introduced that's going to make sure tax is deducted, and sometimes it's a case of, well, actually we're going to move to a relationship that is much more clearly one of a sort of self-employed contractor. But just be careful on the termination of contracts, because you just need to be careful you're not causing liability by terminating a contract when you haven't got liability, haven't got the right to do so. So you do need to be careful. Right, what should you do if you are an end client Well, you need to check if you're a large or medium organisation. It'd be an obvious starting point. Are you caught by the changes? You need to do some due diligence on your labour supply chains. So you need to look at who is the client, which is the point we're just looking at. Do you have fully contracted out services where you can say, actually, IR35 doesn't apply to us in that chain? Are there intermediaries in your labour supply chain? If so, is there that material or other interest, which is a question you'll need to ask to check whether they're in IR35? And are PAYE deductions already being made? So your classic recruitment agency employing people already paying tax. Well, that's going to be outside of scope anyway. But you need to record that process, and you need to record your decisions and the reasons you've reached them as well. So if you conclude a contract is outside IR35 because it's fully contracted out, it is still wise to fully record your rationale for that and keep it under review. If you are in scope, then you're obviously going to need to do your status determinations either via CEST or your own analysis. Got to communicate those and pass those down the chain. You might need to be considering, as I say, as a lot of clients have done, is considering changes to those contracts or the nature of relationships if you're in scope and you're not happy with that. And the other thing I would stress is you need to have a robust internal process for future engagements, because you need to determine all of these things each time. Is there a need for status determination? Are we in scope? Are we out of scope, etc.? And also ongoing assessment, in that the nature of these relationships can change over time, and you may need to do more than one status determination on a contract, particularly if it's going to last for a period of time. Right, I've got one final question for you, which is around enforcement. So, will you be charged a penalty by HM Revenue and Customs for failure to apply the off-payroll rules correctly in the first 12 months? Please vote away. Yes, always. Yes, if there is evidence of deliberate non-compliance, or no, never. This is question really in terms of HM Revenue and Customs approach to enforcement of these new rules in the first 12 months. And I think most of you have voted, so let's close that down. So 12% of you think yes, always. I don't blame you for saying that. If you think, HM Revenue and Customs is going to come after you, it's probably a good bet. 82% say yes, but if there's evidence of sort of deliberate non-compliance, and 6% obviously say no, never. The answer, which 82% of you got right, is yes, but only if there's evidence of deliberate non-compliance. So they are taking a relatively, is HMRC, they are taking a relatively, for them, soft approach to penalties in the first 12 months. So basically, unless there's evidence of deliberate non-compliance, you won't get a penalty for that first 12-month period, regardless of when the inaccuracies are identified. But again, it goes back to that key point. You need to be able to show that you've tried to comply. And well, firstly, it'd be better if you didn't get it wrong to begin with. But if you do fall foul of it, it would be better if you've got evidence that you've tried to do what you can, that you have engaged with it, and you've taken steps to be compliant. HMRC has also said they're not going to use new information obtained through this sort of process to open up investigations into past financial years, unless, again, there's some sort of fraud or criminal behaviour. And they have acknowledged that people will be considering their contractual relationships and may move to different models. But what they are clear on is that if there are sort of artificial or contrived arrangements to avoid these rules, they will be taking action against those. So do be very cautious about sort of any sort of product or promise that says it's going to take you outside of scope, because that is one area where all of a sudden you're not going to be deemed an innocent party anymore, and you could get into sort of penalties. End of that slide there, I've given you a link to the sort of the employment status manual by HMRC, which is actually quite helpful, believe it or not. So if you do have sort of specific questions, that is a good first port of call as a resource. Right. Obviously, normal caveat on all of this, only a sort of a brief introductory summary, always take your own legal advice. Going to do some questions now, but just a reminder, if you can hold on and do the feedback form at the end, that would be greatly appreciated. And obviously, that possibility of getting that voucher. But right, let's get on to questions. Let me just open up the question box. Bear with me one moment and open this up. So, right, got a few here. I will do my best to get through as many as I can, and any I can't get to, I will do my best to come back to you on email, maybe later today or tomorrow. So, first question is around when you have to do. I think it's asking about status determination statements and when you have to do them. Midway sort of through a contract. So obviously you have to do them at the outset before you start. What you kind of need to do is whenever you enter into a new contract, you need to do one. If there are material changes to a contract, then you will need to do one again then, so you'll need to refresh it then. And if you've got long-running contracts, so things that are progressing over a period of time, you should have a review date. So you should date and a review date, probably 6 months would be sensible, to basically assess the contractual arrangement and just to see if the relationship is still the same as the contract you originally entered into, and if so, then you wouldn't need to do another status determination statement, but if there have been changes, then you'd need to do a new one, a fresh one then. Question about international, which is a good area. Obviously, I didn't have time to cover that today, but yeah, overseas workers and to what extent they are caught. Well, can get complicated, particularly when you've got a chain that involves overseas entities. The first thing to note is that it will only bite, and it will only be inside IR35 if there was deemed employment that the individual would be subject to UK tax regime. So give you an example. If you have an individual who solely works in, say, France, is wholly resident in France, doesn't work in the UK, permanently based in France, there is a good chance that even if there was deemed employment, that they may not be subject to the UK tax regime, and therefore they may be outside of scope of IR35, full stop. But you just need to check whether or not that is the case. You need to check whether or not there is they would be within scope if they were an employee, basically. Other piece on CEST checks, and if they are indeterminate or they don't give you an outcome, what do you do then? Well, you kind of need to reassess it yourself. You're going to have to look into it in a little bit more detail. You are going to have to reach a conclusion one way or the other. The fact that the CEST tool hasn't given you an outcome doesn't sort of let you off the hook. You are going to have to reach an opinion on it. So you basically need to investigate it further, and you'd need to have some further rationale as to whether you are sort of in or outside of scope. What else have we got here? Yeah, another question about international. So if personal service company is not UK registered and work done remotely and not in the UK, there's a good chance you're going to be outside the scope of IR35. You always need to check it. There's a good chance you'd be outside of scope on the basis that even if the person was an employee, they would not be subject to the UK tax regime because they're wholly resident and living abroad. Is there a plan for it to go further to include small companies? Not yet, or at least not a definitive one, not that I'm aware of. Obviously, this was all delayed by a year, as some of you will have known, and therefore that has slowed down the introduction of it into the private sector. It is the type of thing that I suspect in due course they may well seek to extend out to small companies. The reality is that this is all driven by HMRC thinking it's not getting the tax that it should be, and as such, if this doesn't solve the problem in their eyes, then it wouldn't surprise me if they go further. Is there a standard status determination letter that can be provided? So there's no set format for it. What HMRC has said that if you do a CEST test online and you sort of print that off, or you record all of that, including the questions you've asked and the answers, that can be sufficient in itself. Obviously, if that is indeterminate, you'll need to give some further information and rationale in there as well. Obviously, recording all that in writing is what you should be doing. So yeah, but no set format. It's just making sure that you've reached a clear decision and you've got rationale for it. Let me see, what else have we got here? Might have time for one or two more. Yeah, a similar point in terms of what information is needed to assess your status determination. So you've really got to understand the nature of the relationship. So obviously looking at the contract is a starting point. You're then going to need to look at the role and the responsibilities of the individual concerned. Ask yourselves those sort of open questions. So when, where, how. Ask those types of questions about the relationship. You can look at the factors I've run through and look at those sort of different areas, and basically look for factors one way or the other. You might also want to consider whether there are people doing similar roles, and whether they are employed or self-employed. The key thing, I think, as a takeaway, I would say, is you can't just rely 100% on the contract. You're going to need to get some specific information about how it operates in practice, because if the contract does not reflect what happens in practice, you could really fall up, because your CEST determination, if you've done one, will be based on sort of inaccurate information. And also, you know, these assessments are done on what is actually happening in practice, not just on the contract. How are we doing for time? Got one more I will do quickly, which is around contractual provisions. Do we need clauses in our commercial contracts to help protect us? Well, quite possibly. It depends upon the nature of your contract. You can't contract out entirely your responsibilities under IR35, I guess is a starting point. But you may need, depending upon the nature of the contract, you may need a number of contractual provisions. So even when you've got, for example, a fully outsourced contract, you might want clauses in there about contractual right to information, which might be also relevant when you've got a chain of contracts. So where you don't have sort of a direct contract into an intermediary, you might need a contractual right to get information about those arrangements. You might want clauses that deal with what happens if an IR35 liability arises midway through a contract. You might want to set out, for example, the parties' understanding and intentions regarding IR35 and sort of deemed employment. And whilst you can't sort of specify that disputes around sort of IR35 determinations are raised in a particular way, you may still want to have something in there that tries to ensure they're directed to a nominated person, just so that you can make sure that it doesn't sort of get lost in the ether and you don't miss out on your 45-day period to respond to those disputes. Right, there's some more questions in here, but I think I will have to go back and I will try and answer these for you later on today, because I think we are slightly short of time and I want to finish on time. I will try and email some of you later on. But just to say thank you very much all for attending. Hopefully it's been useful. Obviously it is a big area, and if you do have any further questions or need any further advice, then please do get in touch. But thank you very much for engaging in the polls and everything. And if you can do the short feedback form now, that would be brilliant. Excellent. Thank you all very much. Have a good day.